call the Business and Governance Committee meeting to order. And we start with the non-agenda public comment.
No public comment.
Mr. Hovey, do you have something to add?
Yes, we have two new members of the Business and Governance Committee, so I just wanted to welcome them. One is here today. Thanasi Privolos has agreed to do double duty in addition to disability to join Business and Governance. Thank
While
you.
texting.
Yeah.
Triple duty.
So thank you for that. And Charlie Hogquist is unable to be at this meeting, but he's agreed to be at future Business and Governance meetings. So with that, we'll be back to having 5 people.
Great. For today, then, do we have a quorum?
Yes, we have a quorum.
Terrific. All right, so thank you, Mark. Let's start with new business and item number 1, the new independent audit committee member appointment, and that's also Mark.
Right. At our board meeting in March, we reconstituted the composition of the audit committee. As you know, it has been historically comprised of 5 members, 3 independent members, non-trustees, and then 2 trustees who serve on the audit committee. And we reconstituted the composition last time to still be 3 independent members, 1 trustee, and then the 5th person could be either an appointed trustee or a 4th independent member. So you all approved that last time, and very pleased to share with you that Ed Kitroser has expressed an interest in serving as that 5th person as an independent member. So he is here today. He submitted his letter of interest in joining the audit committee, and he's available to answer questions if you'd like to call him forward.
Mr. Kitroser, good morning. Would you like to make just a brief statement as to why in the world you're willing to submit to more punishment on this, in this organization?
You know, obviously, everybody knows I've served 8 years on the board. And the 8 years that I've been on the board, I was on the audit committee as well as disability and B&G. And I think I bring a unique perspective which could help the audit committee. I've served professionally. I've done a lot of work with audit committees, especially audit committees with employee benefit plans. The only thing I want to be real clear about and make sure nobody on the board has an issue with, and that is I was on the audit committee for 8 years. There's a possibility now an additional 8 years, which would be 16 years on a committee. And independence of the members of the committee and the committee itself to the board is very important. I just want to make sure tenure of that length does not cause anybody any issues or problems.
Anyone have any comment? Well, then, on my own behalf, I'd like to say that I think we're very fortunate, the organization's very fortunate to have you step up and be willing to do this. I have no concerns about the longevity of your involvement at this point, and in fact, I think it's a benefit to us. It is a committee. You're not serving as the one and only auditor. So under the circumstances, I don't have any problem with it, and in fact, as I say, I think we're very fortunate that you're willing to do it.
Thank you.
With that, I'll go ahead and make the motion to approve. Thanasi Privolos has provided the second.
Ready to vote? All votes are in.
Motion carries 4-0.
Thank you very much.
Thank you very much.
Thanks, Ed.
That brings us to item number 2, which is staff's recommendation to revise the conflict of interest policy. And Mr. Tran.
Thank you, Val. Good morning. Each year, the committee and board reviews its conflict of interest policy. This year, we've asked Peter Mixon, a partner at K&L Gates, to assist with that. If you recall, last year, we retained Peter Mixon to help with as investment counsel. Peter comes in with 11 years of experience as a general counsel for CalPERS, so he's got a wealth of experience with public pension governance, including conflicts of interest. Peter is live with us via Skype from his Seattle offices. Is that correct? So we should be able to see Peter. Good morning, Peter.
Yes, live from Seattle.
So I'll just introduce you.
Good morning, and thank you for not flying down here at our expense.
No, that's very happy not to do so. With the miracle of modern technology, right?
So staff has been working closely with Peter to look at the conflicts of interest policy, and if you can see from the red lines, Peter added quite a bit, and we're very happy about that. He's enclosed a detailed memo to you explaining each and every recommendation we're giving, but I would like Peter to give some highlights today about some of the changes that we're recommending. After Peter speaks, I'd like to comment on the recommendations to hiring other employees related to SDCERS personnel or trustees, and then at the end of that, we would ask for the committee to vote to adopt the revisions. Peter, you take it over?
Yes, thank you, Johnny. So first of all, good morning. Glad to be here by Skype. Just in brief, our firm reviewed the existing conflict of interest policy and provided guidance and drafting assistance to update and clarify a couple of provisions. As Johnny mentioned, there's a memo which describes the proposed changes as well as a red line version. So I thought I'd just give some brief highlights of the proposed changes. First of all, the policy is being proposed to be divided into two sections. One which applies to internal SDCERS personnel, the trustees, and staff. And then a separate section which applies to consultants and other independent contractors. And that was done really to clarify which particular provisions apply to which groups of people. Apparently there was some confusion by contractors on exactly what SDCERS was expecting of them in terms of conflicts of interest. We also added new paragraphs 4 and 5. These really just are reinforcement of the fiduciary obligations that both SDCERS internal personnel and trustees, as well as contractors and consultants, owe to the members of the system. They also set an expectation that both will understand and comply with the policy terms and conditions, as well as those of the California state ethics laws. We're also recommending elimination of a couple of paragraphs which I found somewhat problematic and a little bit vague. First, paragraph 7 dealt with the personal interests that trustees and staff members have in their retirement or health care benefits by virtue of being members of the SDCERS plan. The paragraph provided, paragraph 7 provided that those interests, quote, may or may not create conflicts of interest for those folks. Second, the paragraph provided that a trustee's decision about whether or not to participate in a contract or in an SDCERS decision to make a contract or some other SDCERS decision was, quote, personal to the trustee, and that there's nothing that the system or the board could do either to enforce the conflict of interest requirements or to otherwise preclude the trustee from participating in any particular decision. We found that problematic, first of all, because at least under Government Code Section 1090, which is the state law governing conflicts of interest in the making of a public contract, contracts that are made in violation of that provision are void from inception, meaning that they're completely unenforceable. So the consequences of making a contract that's in violation of 1090 are not just personal to the trustee. Instead, there are consequences to the system as well. And so we felt that the system should not be precluded from taking steps to protect its administration and protect its integrity, and frankly, to protect it making enforceable contracts. And so that we are recommending that those provisions be removed. Paragraph 8 also suffers from similar defects, although I think they're more in terms of ambiguities. They create provisions in paragraph 8, create a categorical exception to the conflict of interest laws for interest for an employee's or trustee's interest in either retirement or healthcare benefits that are provided through the system. There is, under Government Code Section 1090 and the Political Reform Act, there are exceptions that apply in certain circumstances to those interests, but they are much more nuanced than the categorical exception that's set forth in the policy. So without getting into it, the California Supreme Court, I'm sure as many of you are aware, dealt with those exceptions in the Lexon case. And suffice it to say that they are very fact specific, and we are recommending that that categorical exception be removed, and instead that those situations be dealt with on a case-by-case basis, obviously in conjunction with advice from Johnny's office, or of course anybody's free to get personal counsel, rather than sort of have at least apparently an out, which would apply in all cases. So those are the highlights that I wanted to discuss this morning. And as Johnny mentioned, I think he wants to talk a little bit about the anti-nepotism changes in the policy. So with that, I'll stop talking and turn it back over to Johnny.
Thank you, Peter. I wanted to talk about current paragraph 12, which is revised paragraph 14, entitled nepotism. Those sections concern the hiring of employees that are related to trustees or executive staff. The way it currently is written, it prohibits any related person from being hired, supervised by, if they're related to a trustee or executive staff. In working with human resources and reviewing the city's administrative regulations, I believe that complete preclusion of related persons is harsher than what the city administration regulations require. And I believe that's a concern because as city employees, we are bound by some of the hiring practices of the MOUs of the city and its unions. So my recommendation is to revise those sections to meet those requirements and limitations as limited by the administrative regulations, which prohibits any supervision of a related person. So I couldn't hire my wife and supervise her. I also want to reiterate that. Thank you, Thanasi,
okay.
for that.
She wouldn't let you, I'm telling you.
Thank you, Thanasi. I also want to reiterate that the revisions, albeit heavy, continue that the conflicts of interest policy is in some respects more stringent than what the state law requires. And I'm talking specifically about acceptance of gifts and meals and travel. California law allows a certain threshold of gifts from vendors that work or potentially work with SDCERS. SDCERS' policy, should you adopt it, or even the current one, limits it. You can't receive any gifts over $50. You can't receive any meals or any travel arrangements. So staff is recommending that stronger level of conflicts continue to be adopted. I'll take any questions.
Is there any particular reason for softening or modifying the anti-nepotism policy, or is that simply a desire to be consistent with city regulation?
It's a desire to be consistent with city regulations. We haven't had a problem of hiring someone, and Mark brought that to my attention too. We don't want to weaken a nepotism conflict, but I also don't want to be in the situation of being accused of violating an MOU with the unions. We do, SDCERS does hire unionized employees, so we need to abide by those MOUs.
And the MOU wouldn't allow us to have a stronger anti-nepotism policy than the city has? Or than is provided for in an MOU that
I would need to look into that.
Okay. There's also a reference I don't understand in 8A to, 8A is to prevent related party conflicts of interest. SDCERS may not employ a person who is related to, and there's a list of 4 bullet points. The second bullet point is an independent non-trustee. I don't know what is intended by that.
Thanks. So we have committee members that, well, currently we don't, but we have committee members that are not trustees. So members of the audit committee that aren't trustees, also on the investments committee, you could have, we don't have a position available right now, but you could have someone sitting on the investment committee that wasn't an appointed, elected trustee. So if you may recall, Karina Coleman started with SDCERS as not as a trustee.
So an independent non-trustee is a member of a board committee?
Yes, and that's defined in the board policies itself.
Okay. Anybody else have any comment?
Are we taking general questions or just about nepotism?
I think this is general.
Okay. Can I ask a couple questions? Peter, you mentioned, I think in your comments, that there was some confusion by contractors, and I guess as to what policies have been and are. And the whole new section on consultants at the end is quite comprehensive. Does that represent any change at all relative to what the regulations have been? And also, do we feel like those parties are aware of these issues, and how do we inform them going forward about any changes or strengthening of this policy?
So let me answer your first question first. There have been some clarifications to the communications during the procurement process, although I think there were no substantive changes made there. But just to clarify, the exceptions, which to the no contact policy, which was already in place in the policy. I think the other changes here that are set forth really are designed to reflect the requirements of California law. And so whether or not a consultant is subject to Form 700 reporting and subject to the gift limitations set forth and other conflict of interest requirements of California state law is, as you can see here, a fairly complicated determination. But it does not change the designation statement that is currently, which I understand is currently in effect. In other words, the agency, in this case SDCERS, must designate certain folks who have certain disclosure responsibilities under the law, and we included those as an exhibit, and those are the existing disclosure statements. We added in here that typically for consultants, the lead partner of the engagement is the one who is covered by the Form 700 disclosure requirements and the other requirements of the Political Reform Act. Obviously, there's going to be exceptions, and there could be exceptions, but there's language in here that reflects that general rule. And as I understand it, that has been the practice here at SDCERS.
Okay.
That's correct.
Okay. One more quick question. I recall when I joined this organization that I was informed about a regulation or law or something that trustees are not allowed to take employment that involves them marketing to public plans in California. Is that still true, and does that belong in this document, or is that something else, something separate?
So this policy reflects restrictions on contracts or contracting and other decisions that are made by SDCERS, so that a board member or an internal employee cannot have a financial interest in a prospective contract
Okay, I see.
that SDCERS might make. And so that would preclude board members, for example, from receiving compensation in connection with the, consulting contract or an investment management contract or whatever. It does not cover, other than incompatible activities, it does not cover the day job, let's say, of a board member. So there is, however, a list in the policy here of activities which are described as incompatible with the responsibilities of SDCERS employees and SDCERS board members. That's in paragraph 18. And essentially, an incompatible activity is an activity that will negatively affect the ability of a board member to perform their or an employee to perform their responsibilities to the SDCERS system. And so that, I suppose, in the right circumstances, that might include marketing to LaSera or CalSTRS, some investment or fund or whatever. But it would have to be a very, very fact-specific inquiry, because I can see situations where not every circumstance would that be an incompatible activity. I think what you're referring to is the lobby. There is a requirement under state law that those folks who effectively act as placement agents in connection with public pension plan investments, not SDCERS, but all of those investments in California, typically have to register as a lobbyist under California state law before they can do that. So that might be, and then there's all sorts of restrictions on lobbyists under California law once you register as such. So that may be what you're thinking back to, but of course I'm not.
Johnny, you know what I'm referring to, right?
I do, Carol. I can't remember the government code citation off the top of my head, but my understanding is that if you are a trustee of a public pension system in California, then you are prohibited from soliciting business or receiving income or soliciting business from a different public pension system, regardless of any actual conflict with anything you're doing at SDCERS.
Okay.
So I understand that that law is still on the books, and I know we've been advised of the San Diego Ethics Commission concerning that. And again, this I don't believe this conflicts of interest policy touches that, because it addresses what conflicts you have in your capacity as a trustee. That is a separate state law.
Okay, I get it. Could you send me a copy of that?
I will.
I like to keep fresh on that.
So, for example, if someone were a member of an accounting or professional services firm that did work for CalPERS or the San Jose pension system, they could not also serve, if their company did work for them, they couldn't serve as a trustee of any other pension system in the state?
I don't know if I don't believe it pertains to...
I'm going to have a problem with that. Carol, I didn't realize that was the rule, so we really need to focus in on that, because I don't know the extent to which other lawyers in my 200-lawyer firm in some other city may be doing work for a
Agreed, Val. I don't think it pertains to lawyers or other services other than investments. But let me look into that and get the code for you, please.
That's typically how we've interpreted it, as being investments related. So PIMCO, of course, is one of our fund managers, but let's say they weren't.
Right.
If we were approached someone at PIMCO to join our board, they would be precluded from joining our board because they advise other California pension systems on what they should invest in.
I understand.
So that makes it very difficult to find great people like Carol unless they're no longer working.
Right.
Right? Or,
Yeah.
So.
Got it.
Right, yeah.
But we'll clarify that with you.
Okay.
Thank you.
I had a question that may be somewhat academic, but there's some reference in here to constituencies, and one of the issues that I think many of our board members struggle with is the idea that they are elected by a group of either retired or active employees and who have members of the system, and when they come to this boardroom, they are expected to very assiduously work only for the benefit of the system as a whole. And there's a reference in here to, in the conflict policy rule 7 pertaining to SDCERS personnel in the conflict of interest code appendix B, conflict of interest policy in the red line. There's a reference here to a constituency being appointed or elected to represent, or a member being appointed to represent a constituency. So my question really is it clear that when someone is elected or appointed that they are elected or appointed to represent a constituency in this room, or are they merely elected or appointed by that group of people, but not as a representative of the constituency? Rather, they're elected or appointed by that group because that's what the rules provide, but they don't, in fact, represent any constituency. I don't know which it is. But we seem to, for the first time in the red line version of this, be introducing the concept or acknowledging that, in fact, someone is elected or appointed to represent a constituency, and yet they're supposed to put the system as a whole above that constituency. I'm not sure that's true. I had thought up until now that they don't represent a constituency. They may have been elected by a group of people, but not as a representative so much as that, you know, they're elected to the board to represent the system. So maybe it's academic, but it does reflect a change in language, and I'm curious as to whether we've thought about it.
Johnny?
So
He's talking, I mean, basically that identifies me. And when I first came on here, you know, I had to identify with that I was elected by the police members, but that's what I am, just an elected official that represents them, but I don't represent necessarily strictly their interest. I have to look at it specifically with my fiduciary responsibility of the fund. And it doesn't take very long to recognize that. So you get beat up sometimes when you go back to, and then why'd you vote such and such a way? But you have to do what is expected of you in the interest of the fund. And it quickly comes to that. So.
Tom, I agree with your explanation. Tomorrow you have fiduciary training, and Chris Waddell is diving deeply into this 1-2 hat rule. So I would defer to his advice tomorrow exactly on the topic of elected and who you represent. But
I guess to put my question in focus, it would be: are there really 2 hats, or is there really only 1 hat?
there's only one hat. You sit as a fiduciary who are expected to wear the fiduciary hat, irrespective of the fact that you were elected by a constituency or appointed by the mayor or hold office as, you know, an ex officio member, like on the CalPERS board, as state treasurer sits ex officio on the CalPERS board. So the law, I think, and I'm sure Chris will explain all this in more detail, the law, I think, is clear that a fiduciary owes duties of loyalty to the entire membership of the system.
Thank you. Anybody else want to make any comments or questions? Great. Thank you. Thank you very much.
yeah, Peter, you're on the next item, so if we could hold on, we can vote now, but if you'd not hang up.
So give us a second to get back to the meeting. All right. Do we have a motion to approve the revised conflict of interest policy? Well, actually, this isn't a motion to approve this document. This motion states it's to revise the policy.
Yes,
So is this subject to further revision, or is this the revision?
this is the revision.
All right, so we're moving to approve this revision.
Yes.
Yeah, then my only concern is with the language that acknowledges that there's some constituency representation in in that paragraph 7. The way it was previously stated, it seems to me was better, where it said regardless, and not in the interest of a particular constituency that may have elected or appointed the trustee, as opposed to regardless of the interests of the constituency that the trustee represents.
And I agree with that. And I think that should at least be a 10, 15% discount off of Peter's bill, I think, since we already had that language, I'm pretty sure.
The first sentence of Section 7 is similar. It used to say an elected or appointed trustee's interest in his or her responsibilities to his constituency. Now it says a trustee's interest in his or her responsibilities to his constituency. I would revise that. That probably wasn't good before either, but I think I would provide there that a trustee's loyalty or interest to a group or constituency that may have elected that trustee.
Did you want to amend your motion then to say as revised by the committee at the end?
It was your motion, Carol.
Well, does that work for you?
I think so.
Okay.
I think this would be a simple change.
And I will second that.
Oh, we need,
You're rewriting something different.
if you verbally revise it, she'll put it up after you've stated what you're doing.
Okay, help me out. Motion to approve staff's recommendation to revise. Is that even okay to?
I think what Carol wants to make is a motion to approve staff's recommendation to revise the conflict of interest policy and to modify the wording of paragraph 7 to eliminate the reference to a second constituency of any member.
What he said. Do I have to say?
You want to put all those words?
You need all
As amended in paragraph 7?
Yeah, let's just put as amended in paragraph 7, and then I will work with you to nail out the language
Before tomorrow.
consistent with the vote today.
Okay.
There it is.
And I think once the buttons come up, Tanasi has a second on that. All right. So that motion's been made and seconded.
Ready to vote? All votes are in.
All right, and that was approved unanimously. So that brings us to item 3, which is staff's recommendation to adopt the insider personal trading policy, which is, again, Johnny and Peter, I think.
Yeah, thank you again, Val. So Peter's been working closely with the investment staff to review the division's policies and procedures. Out of that review came the recommendation to adopt a new insider and personal trading policy as a best practice for SDCERS, something that other systems have done as well. So Peter's going to briefly go over how insider personal trading laws, what they are and how they affect certain staff and trustees, and then we would ask that you adopt this new policy. Peter?
Thank you, Johnny. Very briefly, the SDCERS system is not subject to many of the federal securities laws that govern private sector entities. However, Section 10B of the Exchange Act does apply. This makes illegal so-called insider trading, which is really a prohibition on anyone buying or selling securities on the basis of material, non-public information. In addition, Section 21A, the Exchange Act provides that, quote, controlling persons who fail to take reasonable steps to prevent their controlled persons, which is typically employees, from trading on the basis of this information, they are at least potentially subject to substantial penalties. So, as Johnny mentioned, the proposed policy is designed to meet these responsibilities and is part of best practices, I believe, for public pension plans. So the SEC has promulgated rules which effectively allow a safe harbor for organizations to meet their responsibilities This includes a formal policy against the improper dissemination of material non-public information, as well as a prohibition for employees to trade on that basis, employee training on the meaning and intent of federal securities laws, and then a reporting and enforcement mechanism. So before you is a new policy, proposed new policy, which is designed to meet those requirements. It provides guidance on the definition of material non-public information. It prohibits dissemination on of that type of information except on a need-to-know basis. There is a process set forth for documenting the receipt and dissemination of that information when it comes into the system. If it comes into the system, there's a prohibition on trading on that basis, of course. There is a training requirement for employees, and there's a responsibility for management to provide that training. And finally, there's a self-certification for new process for new employees. Again, this is consistent with best practices. A number of public plans, including CalPERS, the New York State Teachers Retirement System, the Texas Teachers, and North Carolina Department of State Treasurer have similar types of policies. So we're recommending as part of best practices that such a policy be adopted. Happy to answer any questions.
I don't see any questions. This looks like a good thing. So appreciate that.
Welcome.
We'll need a vote.
We
Val.
need a
Goodbye to him.
motion to approve. Yeah, very safe. All right, I made the motion, and Tom Sullivan seconded the motion.
Ready to vote. All votes are in.
And the motion is approved unanimously.
Thank you, Peter.
Thank you. Thank you very much.
Thank you for being here.
Welcome.
Next, we have item 4, staff's recommendation to deny the appeal of Paul Secco-Biffle. Susan Youngflesh.
Thank you. Tim Biffle is an inactive city member. He entered SDCERS membership in 2003, and he didn't start paying employee contributions until a month later, so he has underpaid contributions for that 1 month. He owes about $100 in principal and $200 in interest. He has agreed to pay the principal, and he is appealing the interest. Staff recommends that you deny Mr. Secco-Biffle's appeal. I'd be happy to answer any questions.
This is the same old interest issue that we struggle with in just about every meeting. So are there any new or different facts or issues here that you should call to our attention?
No.
All right.
Well, I have a comment. It's not a question. I want to, in the future, not to have stupid appeals brought before us, because for $207, this guy is risking his reciprocity with CalPERS. Someone ought to take him out back and beat some sense into him. And I don't think we should have to waste our time with this stuff, but that's my comment.
Well, I think Mr. Priovalos was being apocryphal about that. But with that, I think we need a motion button. All right, I've made the motion to approve staff's recommendation to deny this appeal. Tanasi Priovalos has seconded the motion.
Ready to vote. All votes are in.
All right, the motion was approved unanimously. That brings us to item 5 on the agenda under new business, which is staff's recommendation to deny the appeal of Anna Martinez. Again, this is Susan Youngflesh, and Ms. Martinez is here as a speaker. Let's begin with Ms. Youngflesh. Once Ms. Martinez is seated in her chair and is able to listen. All right, Ms. Youngflesh.
Thank you. Ms. Martinez is a city general member. She retired from DROP. She is appealing the correction of her benefit. In 2002, the city enacted the 90% cap provisions. She qualified as an exception under 90% cap. Her factors should have been frozen as of December 31st, 2002. However, staff incorrectly used the June 2003 factors when she entered drop. In 2010, staff identified this error. However, a full analysis wasn't completed until 2016. Staff prospectively corrected her benefit, lowering her base pension from $10,000 to $9,800 per month. Because of the delay, staff sought that the board waive the interest of $13,000 in 2016. The board agreed to do so. She owes a principal of $42,000 and remaining interest of $700. The court has consistently upheld that it's this board's right to recoup overpayments with interest, and that the board has a fiduciary duty to the membership as a whole and to maintain the financial integrity of the system. Based on that, staff recommends that the board deny Ms. Martinez's appeal. I'd be happy to answer any questions.
So did I understand correctly that the board in 2013 previously waived $13,000 of interest?
In 2016,
2016?
yes.
And so the $700 of interest is what's accumulated since then?
No, the $700 in interest is what's accumulated since she retired drop in 2008 until 2010 when the error was first identified.
I see. So the waiver applies to the delay that occurred between discovery of the error, or the need to investigate, and the completion of that process, which
Right.
took too long.
Yes.
Got it. Okay, I understand. All right. Ms. Martinez, you have the floor. And please, you have 2 minutes. Please go ahead.
Thank you for your volunteer efforts, and I hope that you can assist me in the positive resolution of my appeal. No retiree should have to endure what I have been through, namely to receive 2 separate letters from SDCERS that recalculates my pension with significant decline in the value due to staff errors. And then the demand for the large repayments, which increased, of course, with each letter I received. One of the most egregious matters in this case is that in 2010, SDCERS identified an error, yet no one notified me, and I consider this unreasonable and negligent. I also want to point out that the initial calculation error goes back to 2003. Staff tells me that there is no statute of limitations, but when an agency has such a long-standing error, I would assume that the sponsor should take some responsibility for the error. And I understand what the laws and the courts have said. But you know, sometimes the courts make the wrong decisions. In the meantime, I and the rest of my family counted on the pension and annuity, which SDCERS representative led me to believe was irrevocable. I find it hard to understand why the city has not obtained insurance to cover for such long-standing errors. The system has a fiduciary responsibility to me as well as others in the system, and when an individual is harmed, the system is harmed as a whole. If the city chooses not to provide such insurance, basically to be self-insured, then they need to assume the responsibility for the errors. The IRS regs, which are often cited by SDCERS staff, do in fact allow for the city to make the system whole. I found notable the information from the Pension Rights Center, which recommended to the IRS, as they were reaching out to the community on feedback on their procedures, and in revising their procedures for correcting pension overpayments. And I want to quote from their recommendations. Overpayment calculations should be limited to a 3-year look back. They also said, quote, interest should not be collected on overpayments when participants are not at fault. This is good advice, and you should adopt this as part of your policies. And I know the challenges that are involved. You ought to have enough influence on the city council to make this happen. I think I could guarantee that there would be less litigation against the system, and what a win-win this would be. So these comments are supplement to what I've written in my appeal letter to the committee. I would have also filed a written response to the committee, but I learned of the 10-day deadline that you needed to have received this by, so I did not do that. So that concludes my remarks.
Thank you. Mr. Priovalos is in the queue.
Ms. Martinez, I just want to say that this is a common problem that we grapple with, and I don't know that there's anything that you've said that I disagree with. But for one thing, we have no influence over the city council, but you and your constituents do. And a lot of these problems can be solved if the city takes a different position as the plan sponsor. And so in the meantime, many of us up here are just stuck, being trapped between a plan sponsor and what the code says. And there's no good outcome. I am very pleased that you at least got a waiver of the interest for the delay. And I'm also pleased that the interest that you're being hit with is, I'm not saying insignificant, but at least de minimis. So I do want you to understand that there's a great deal of sympathy for you and for others like you on this board. But believe me, we beat up our professionals, we beat up our consultants, and we beat up our attorneys over these issues. And I'm still not satisfied, and I'm still trying to fight it to the extent that I can. But there's not a lot we can do.
Could I just respond to that?
Yeah, I'll give you a minute.
So I disagree with you. I do feel that you as a board have influence on the city council. I think you could make it happen. You can use the Sololinsky approach to influencing that constituency. So I totally disagree. And also, I think you should really abate all of the interest. And maybe you should challenge the IRS. Because I think some of the things that retirees who have been, where errors have come up, there might not be that much money involved, you know? And plus the fact that you would save on litigation, it would possibly make the system whole.
All right. No one else is in the queue. Thank you very much, Ms. Martinez. Thank you, Susan. We need to have any further discussion? Seeing none. All right. Mr. Priovalos has made the motion to approve staff's recommendation to deny the appeal of Anna Martinez, and I've provided the second.
Ready to vote?
Unanimously approved. Thank you, Ms. Martinez. Thank you, Susan. Let's move on to item 6. The annual cost of living adjustment effective July 1, 2017, and Marcel Rossman.
Good morning. Excuse me.
Good morning.
Every year, we ask our actuary, Chiron, to calculate the coal annuity for us. They have come back with their report, and they have calculated a 2.1% increase in the cost of living. That is more than the 2% maximum that is allowed. So our recommendation is that the 2% maximum be applied and the 0.1% go into members' COLA banks. You may recall from last year, we're now at 6 of the last 9 years, COLA has been less than 2%. So all of our retirees who had retired from July 1st, 05 on had 0 in their COLA banks, and they'll, I think, be happy to at least have 0.1 in their COLA banks after this. I'm happy to answer any questions.
I see no questions on this. I've made the motion to approve the annual cost of living adjustment effective July 1, 2017, and Carol Broad has provided the second.
Ready to vote? All votes are in.
This passes 4-0. That's a good point. Hadn't thought about it either. Do you want to go back and abstain?
No.
Then we'll move on to item 7. Staff's recommendation to upgrade the Dell storage area network, and that's David Bond.
There we go. SDCERS has a storage area network that is a sophisticated disk storage management system containing high availability disk arrays and redundant failover capabilities. It's a core component of our infrastructure, and it houses the majority of our data. I was notified very recently in April that Dell would no longer be supporting the storage area network. We have constant communication with Dell's support. Dell support didn't let us know that it was being de-supported. So that was a real issue. And after much discussion and escalation through Dell's management, they agreed to replace our old SAN with a brand new SAN. And they're also offering a $275,000 discount to do so in order to make us whole. So I think Dell has done their best to remedy this situation, and staff is recommending the board authorize the CEO to upgrade the SAN for a cost not to exceed $135,000.
All right.
Just a quick
Tanasi.
question. Yeah, thanks. What was the reason that they're willing to offer such a discount? What was the
late notification? They told us in April that the SAN, the storage area network, was going to be de-supported in September of this year, of 2017, which the budget cycle's already passed. We really didn't have any recourse. We immediately have to replace the system, and they realized there was a communication issue.
Can you help me with the offshoot backup process we have at 550 West C Street, Suite 1600? That would be helpful. We'd like a similar discount. That would be great. No, okay.
Does the discount adequately compensate us for the additional costs we will incur because we weren't notified much earlier when perhaps they were considering the discontinuance of support?
I believe it does. If we were to RFP for a new SAN, it would be between probably $500,000 and $250,000. The Dale SAN we currently have was $250,000. If this were at full price, we would be paying $400,000 to replace the SAN. So they're essentially giving us a brand new SAN for a deep discount.
Had they informed us maybe 2 years ago, if they had started to think about discontinuing this support, if they told us 2 years ago, would we have been able to do anything differently to save more money?
Actually, we would have probably paid more. We would have paid at least $250,000 to buy a new SAN. And so in a strange way, it's almost turning lemons into lemonade, what happened.
All right.
Out of curiosity, this $135,000 is just the hardware cost. It's not the conversion costs and transferring it, all that stuff. Is that going to be just absorbed by your operating budget, or what happens?
That's being absorbed by Dell. They wrote off all the software costs. So the $135 is to install it, migrate all of our data. They're going to have to fly a team out here to actually do it.
Wow. Okay.
All right.
This is nine-year life? This is a 9-year life?
Yeah, the new system they're saying is going to be supported until 2026. We'll have to probably upgrade the guts of it, but the core system itself, the chassis and the software, will be supported till 2026.
Great. I think we're probably ready. Come on, Tom.
It's not.
All right, the motion to approve the staff's recommendation was made by Tanasi Priovalos and seconded by Carol Broad.
Ready to vote? All votes are in.
Unanimously approved. Thank you very much, David. That brings us to the last action item, item 8, staff's recommendation to revise Board Rule 2.90, the applicable mortality tables and assumptions for determining actuarial equivalence and other benefits. That's a mouthful. And Marcel.
Good morning. We actually wanted to request with the board if we could take non-action item 1 first, as it directly relates to this action item and provides background, and then go into action item number 8.
Please go ahead,
Thank you.
notwithstanding Tanasi's objection.
Are we skip?
We're
are we
doing
skipping this?
B1, and then we're going back to A8.
B1's not an action item, though, Cynthia, so.
We're just going to combine B1 into A8.
Yeah. Okay, so good morning. I want to give you a little bit of a history on how we got to where we are right now. So in January of 2007, our internal auditor, Lee Paravano, completed his audit of the coal annuity and provided an email copy of that to the board prior to our January full board meeting. At the January board meeting, we revised Board Rule 2.90 to address, excuse me, one of the findings that Lee had brought up in the COLA annuity and the surviving spouse annuity audit, which was the interest rate used to calculate the benefits. So when the board voted to amend Board Rule 2.9, that addressed those findings. In March, Lee presented both the COLA annuity and the surviving spouse annuity to the audit committee. And then at the full March board meeting, Greg Koyeski, the audit chair, presented that to the full board. So there are 5 findings in the COLA annuity audit and the surviving spouse annuity audit. One of those in each one is the one that related to past practice, and we took care of that one with Board Rule 2.90 in January. Also in January, we did tell you we'd be back with Board Rule 2.90 in May, which is our next item. There are several items that are specific to the port and the airport that we're not asking to address today. And then the final item is the recommendation on considering a different interest rate for the COLA annuity and surviving spouse annuity, both for crediting contributions for port and airport members and for calculating the annuity for all 3 plan sponsors. And our recommendation to the board is to not take any action at this time. Prior to our meeting, Mark Hovey did reach out to all 3 of our plan sponsors with a draft of our memo and asked for input, and we did not receive input from the plan sponsors, either requesting that we change the rate or that we keep the rate the same. We've also had significant conversations with our fiduciary council, who believes this may raise vested interest and meet and confer issues. So based on the lack of a specific request from our plan sponsors and the advice of our fiduciary, we recommend that the board take no action at this time. I'm happy to answer any questions.
I wanted to add one thing here. So, yes, I reached out to all 3 plan sponsors asking for input on this. I did not directly hear back from the plan sponsors, but Johnny Tran did hear back from the airport's general counsel asking several clarifying questions on what it is that we were presenting to you today.
That's correct, but there was no comment concerning what the interest rate should be used, just clarifying what the board had done in January and what we were talking about today.
All right.
There are
Do we need to take any action?
no. This is just an opportunity for you to.
Ended, so.
Nope.
Unless any trustee wants to move to take some action that's not recommended, we can move on.
Board Rule 2.9 is the next item, and that is an action item. And Board Rule 2.9 is a recommendation to update it. The next item is a recommendation to update Board Rule 2.9 for 2 things. One is incorporated in Board Rule 2.9 are the mortality tables. And since the board voted to adopt new mortality tables based on our 5-year experience study, we need to update Board Rule 2.90. We also worked in consultation with our actuary, Chiron, and are recommending that the interest rate for both crediting and for calculating the annuity be updated to 7.0, which is our current discount rate. And so happy to answer any questions you may have on that.
I think Tanasi has a question.
So the only question I have is, we're updating it to 7.0, but are we adopting a policy to update it as the discount rate changes? I think we're phasing in a discount, or are we just setting it at 7.0? Because I'm not sure I could tell from the way this was worded, probably sloppily by our general counsel, but we can't blame him. He tries, but it's one of those things.
We're recommending that you adopt 7.0 as the rate to be used to calculate annuities, but we're just recommending that as a point in time. So next year, if there is a change in the discount rate, then as staff and working with Chiron, we would determine whether it's appropriate to bring another recommendation to update Board Rule 2.90.
So why wouldn't we just tie it to we've had it tied to the discount rate all this time. Why wouldn't we just tie it to the discount rate and not bring this back up all the time?
We would still need to bring it up because it's in the board rule. So we would need to bring it just as we have to bring forward the board rule that says we're going to pay 7% interest on member contributions. Chiron has told us that it is not required that the discount rate be used to annuitize benefits. So we could have a change in our policy that said that we are going to tie it always to the discount rate, but we haven't done that.
Well, so the reason I'm asking is that, as I understand it, we always have. And so for me, I'd rather have it just be automatic. And then if you want to bring it back every year and ask us if we want to change it, that's fine. But I don't know that we want to. Why have gaps in calculations? Why not just, You guys know it pegs to it. Your calculation's the same. If the board wants to change it on some given year, great. If they don't, at least you guys have clarity moving forward.
Yep, that is absolutely something that we can do. A reminder, when we came to you in January, it was because we had not always pegged it to the discount rate. And so that's when we asked to have clarification and codify what our past practice had been.
Okay.
So I guess the question is really one for Johnny, which is there a more efficient way to go about this so that we aren't making two motions, but rather as the discount rate adjusts or new mortality rates come into existence, they are automatically incorporated into Rule 2.90, or should we just keep doing it this way?
Yeah, thank you for the question. So Chiron has advised us there are systems, and it's a good practice not to automatically tie this interest rate to the discount rate, because the discount rate, when you set that, should be set for purposes of valuation and setting contributions, and not this as a secondary thought. So they actually recommend against always tying the discount rate to these interest rates. And for that reason, we recommend what we've proposed in the board rule, which is anytime you do change the discount rate, staff seeks the advice of the actuary, seeking their recommendation if this interest rate should be updated to reflect the discount rate or not, and we would bring that forward each time the discount rate is changed.
So you think instead of sloppy draftsmanship, this was an issue of fuzzy thinking by one of the trustees?
He's helping you out. Don't worry. You're fine.
I think I get that.
You're okay.
All right.
Lawyers speak.
Yeah. All right. Any other questions or comments? Thank you, Marcel and Johnny, for that explanation. I think we are ready for a motion. All right. Carol made the motion. I beat Tom to the second.
Ready to vote? All votes are in.
All right. This motion's been approved unanimously. Thank you. That brings us to no action item 2, B2, under new business, update on trustee elections, and Jessica Packard. Or is it O. Packard?
Okay. Good morning. Nice to see all of you. SDCERS held 2 elections in March, one for 2 seats for the active general trustees. Tanasi, pay attention. I'm just kidding.
Thank you. Thank you for saving me from having to do that.
You can punish me later. It's fine.
And one for the active fire safety trustee seat. And both Tom Battaglia and Jeff Wallace were reelected to the active general trustees, and Mike McBride has been elected as the fire safety trustee. And this online election process went smoothly. The participation rates were good and consistent with what we've had in the past.
Great.
So with that, I'm happy to answer any questions.
Seeing none, thank you very much for your report.
Okay, thank you.
Next, we have a discussion of training opportunities and ways to reduce costs from Johnny Tran.
Did you have to move seats?
Yes.
Hi again.
Yo.
I'm going.
I can't hear you from there. Can you go back over there?
Got to get my steps in today. At the March meeting, a few trustees asked staff to explore ways to reduce trustee training costs. So out of respect for that, we bring this non-action item, provide opportunities to discuss this request. A little background, what kind of in-house training do we provide for the trustees? Well, as you know, we provide new trustee training. It's an all-day training regarding SDCERS history, operations, fiduciary ethics. They also receive a half-day training with our investment consultant investment team. All trustees also receive fiduciary training each year, ethics training, Brown Act, sexual harassment training, and you even have the ability to subscribe to periodicals. And at the annual retreat, as you know, we've historically gone in depth in education topics, such as last time in February, we went and talked deeply about actuarial process. We talked about corrections and tax qualification matters. So possible ways to reduce outside training. None of these are staff recommendations, just thoughts. We could reduce the number of educational courses available to tenured trustees. So right now, the education policy limits trustees that have been with the board for 2 years or more to 4 education conferences a year. We can invite tenured trustees to attend new trustee training, which we just had last week. And we can also provide more training to the board during regular meetings. So tomorrow you have fiduciary training. We could provide other training at board meetings and kill 2 birds with 1 stone. With that, this committee, tell me any ideas that you have to reduce training costs.
I guess that for city employees, we have a lot of the online training stuff that they have that gets assigned to us. So maybe there's a possibility of that where you have, you know, some type of process for that.
I think that's a good idea. I would suggest that this should not be a one-size-fits-all type of a policy. I think we should have the breadth of opportunities and options for trustees to to pursue education and training, and I think we should encourage it rather than discourage it. I think the concept here is that we shouldn't rubber stamp requests for training without evaluating it and potentially counseling trustees about what might be less expensive alternative ways to achieve the same result. So from my perspective, I think all I'm looking for is to suggest that one of the functions of the CEO or the chief compliance officer or the general counsel be to evaluate training plans and requests for training with individual trustees and provide counseling on ways to achieve the same result at less expense, and potentially even report to board members if there is some reticence on the part of a trustee to take a less expensive alternative that achieves the same result after having been counseled to do so. I don't want to create waves, but if we have a trustee who goes rogue and decides that spending half the year in Hawaii would be really awesome, we need to take action on that. On the other hand, I haven't sensed a current problem, so I wouldn't be in favor of anything other than that evaluation and counseling process. Tanasi. Sorry, Carol's next.
I agree with a lot of what you just said. I think the idea of encouraging tenured trustees to retrain when you do new trustee training is a great idea, and appreciate all the training that comes in at board meetings. I also believe it's really important to go to outside events and training sessions to get a diversity of views, to meet your peers in the pension community. You know, I really like the Calipers events where you're dealing with other trustees and other staff members. I think that's just a really enriching experience, and I wouldn't want to, you know, unnecessarily curtail that. I agree that we could do more to, first of all, just require people to evaluate conferences that they've attended. I think we have a system for that, but it doesn't seem to really get enforced. And even if we, you know, time permitting, having people actually make a 1-minute summary at the board level just to state, you know, what they learned or what their takeaway was, so that there's some, you know, responsibility for having gone to that event. I also feel that our list of conferences currently is really kind of expansive, and we could probably, with input from people who've attended various conferences and just looking at kind of a little bit deeper, narrow it down and help direct trustees to things that are sort of tested, proven, recommended, and you know, just narrow it down a little bit.
Tanasi.
I'm glad that we've had the discussion. I'm not quite sure that there are really some cost overruns in that area. It doesn't seem to be a big part of the budget. I don't seem to see a lot of abuses. I think the 2 checks and balances that I've dealt with are that you guys have recommended that I take certain courses. I think that's been helpful because you've kind of put those things out there. The board has to vote on me attending them. I can't just go on my own without the board approval. So I think that's kind of a good check and balance. And quite frankly, I like the depth and breadth of these things, and I do want our trustees to go out there. And I don't know there's a bad training seminar out there. I mean, going and getting that information, it builds you. So I don't have a problem with what we're doing. I also do get, at least before I go to one, I always ask if anybody else has gone, and people will say, "Oh, it was a good conference or it was a bad conference," and most of the time they're right on. So I don't think that there's a reason to change anything at this point, and mostly that's because I don't really see the abuses. I mean, there's one guy that goes to 1 billion of them a year, but he doesn't have a real job. So some of us that do can't get away 4 weeks a year, and believe me, my wife and kids would love it if I would leave 4 times a year or more.
Odd months for us.
Odd months for you.
Just to touch upon what Thanasi said, we have been within budget, and looking at the last 12 months, the trustees have only spent $39,000. So I agree there hasn't been any abuse in the trustee training. To Val's question about the CEO and the compliance officer looking at courses that are maybe more cost effective, Mark does a good job of looking individually at each trustee's position, training, what they've been to in the past. He has a ridiculously complex spreadsheet that he understands and I don't, but he has recommended to each trustee those courses, and a lot of the trustees do take those. The trustees also have to vote on each of these trainings, so I do urge you not to rubber stamp those requests and ask questions to the extent you want to about why this individual is taking a course here or not there.
So it seems to me that what I would be in favor of doing is having this item on the agenda for tomorrow's general meeting and having Johnny make a short presentation about being cost effective and how it's done. And unless staff believes that any further action should be recommended, I think that would be a good way to handle it.
Okay,
Yeah, just highlighting what you guys are doing, I think is enough.
great. So we'll pull that from consent for tomorrow.
Yeah, and if you wouldn't mind making a brief presentation about Mark's matrix, incredibly complex matrix, and how we care about what you go to and don't go to and all that.
And the Ouija board.
Thank you,
All righty?
Val.
Thanks. That takes us to Section C of the agenda, old business. This is a non-action item. Marcel reporting on overpayments to members exceeding $10,000.
Hello again. So we have one new member on the list of members who have overpayments exceeding $10,000. This is a city member who was a former city member, had left and came back, and we've worked very closely with the city to work through this. He was not initially re-enrolled in the DB plan and now has been. He does have a significant overpayment, and he does have monies available in the defined contribution plan he'd been contributing to at the city that he can use to transfer over, but that will not cover his full amount. We still have 3 outstanding. One of them you heard earlier today, Ms. Martinez, and then the one you'll hear tomorrow, Ms. Toomey, and then Deborah Nastor we're still working with. I'm happy to show that this list is getting smaller, and we are so close to finishing completely with looking at all of the accounts we wanted to look at after our conversion to IRIS, that I anticipate this will stay very, very small.
That was going to be my question, is on a going forward basis, do we anticipate less human error, fewer instances of these kinds of overpayment situations in the next 20 years and beyond?
Absolutely. The safeguards that we have in IRIS and our new system make it very difficult to have these kind of issues. There's not the staff hand calculations, there's not spreadsheets being used to calculate, and there's not the issue of a calculation being done and then having to be separately keyed into a system. So I anticipate a much lower incidence.
Do members understand that? Do we communicate to members about, this issue adequately? Maybe that's a Cynthia Queen question. Is there any more we should be doing to publicize how these things can happen and how IRIS is going to reduce the incidence of it and that sort of thing?
Yes. We talk about it regularly and explain to members, particularly those who have issues. However, I'm also looking to the additional outreach that we'll be sharing with members this year in, for example, our newsletter and at our annual meeting, to continue to reassure folks that this is part of an overall effort to just make it rock solid.
Yep. All right. Thank you very much. And I was mindful of the comments that Ms. Martinez made earlier today, and While I'm not making any comment on her case in particular, it is one of the most disturbing things that happens in these walls is when there's a calculation of benefits error. So I'm very happy that we have, as an organization, brought in IRIS and done everything we can to make it as unlikely as we can make it. So thank you to everybody who does that. All right.
Thank you.
That brings us to the status reports, and the first one is legal.
Hi again. You have my report. I just want to touch two things. Thank you for turning in your annual statement of economic interests. That was due April 1st. My job is to review those. I reviewed those. I don't have any problems or issues to report, so that's a good thing. The second thing is we've mentioned, I'm sure you're aware of the challenges to the lawsuit concerning Proposition B. I've sent you a confidential email about it, but what is public is that the Court of Appeal in San Diego has essentially nullified the Public Employee Relations Board's finding that the City of San Diego violated meet and confer laws when it failed to meet and confer with its unions concerning Proposition B. So with that ruling, again, it maintains the status quo, which is SDCERS is not required to enroll new city hires as of July 20th, 2012. We're aware that one city union, MEA, has appealed that ruling to the California Supreme Court, and I will give you an update on how that appeal process goes. Questions? Thank you.
Nope, Danasi's left the room. All right, that brings us to information technology.
Good morning again. I wanted to extend thanks and appreciation to Ray Lawler. He was our lead on getting the Skype functionality to work. Kind of a soft launch today, and we'll probably put some rules around board policies around the use of Skype. For the IT status report today, Application Services Manager Michelle Wegner will be presenting. Michelle was our project manager on the on-time, on-budget IRIS system implementation, so she's got quite a track record of success. And in April, Michelle did an outstanding job leading our disaster recovery exercise, and she'll talk a little bit about that.
Good morning. I'm here to provide some additional details on the disaster recovery exercise that took place this past March. We planned this in parallel with our production cycle so that we could have some detailed reconciliation throughout the process. I'd like to highlight some of the activities that took place during this exercise. A simulated disaster event was declared, with the disaster recovery team's assumption that all systems at SDCERS were unavailable and offline. This would overlap the period in which we ran our monthly retiree payroll process. This disaster recovery team is a subset of our management team with very specifically defined roles in our disaster recovery plan. The first step was to contact Sagitech to activate our warm site. Then from home in an SDCERS issued laptop, our team accessed our pension system, IRIS, and ran a successful retiree payroll. The output of that payroll was then reconciled with the production payroll that was ran at SDCERS, and I'm happy to report that we reconciled that down to the penny. It's important to note that we have real-time data replication from SDCERS to our warm site. In the case of a real disaster, there would be no data loss. Once the retiree payroll was reconciled, the investment team was notified of the transfer amount to fund the payroll. Again, from an SDCERS issued laptop outside of our network, the investment team initiated, approved, and completed the transfer of that fund from State Street to Wells Fargo. Lastly, using the Wells Fargo portal, we uploaded and transmitted all payment files for immediate processing. I'll be forthcoming that there were issues along the process. All of the issues were addressed with the escalation processes documented in the disaster recovery plan. At the conclusion of the exercise, we held a lessons learned session which resulted in updates to the documentation to help improve this process in the future. The next time this event will take place is in 2 years. This was a full team effort, and the exercise would not have been successful without everybody's involvement and cooperation. With that, I'd like to thank everybody who was involved for making this a priority. And that concludes my summary. If you have any questions, I'd be happy to answer them.
I don't see any
We
questions.
don't often
Mark?
get to see Michelle at these meetings, but she is just one of the superstars in our organization that makes things happen. Dave mentioned our IRIS project was on time and on budget, and it met its deliverables, and she played a huge role in making that happen, working very hard on that project for years. So just want you to know how important she is to our organization.
Thank you.
Thank you for your presentation.
Thank you.
Did anyone see if Cynthia submitted a report this month? All right, member services and Cynthia Queen.
Thank you. Keep an eye on that one. She's a rock star, making it happen. So this morning, we've discussed some very important governance issues for our board, all very important. And now I want to talk to you about online retirement applications. An application for retirement is about as basic as it gets. We can't do that right every day. We need to get another job. So I want to tell you how we're making that even better. Right now, Tom comes in to retire. He's going to fill out 8-page piece of paper application.
Are you picking on him because today is his birthday?
That's my closing line. Happy birthday, Tom. Thank you. 8-page piece of paper in your handwritten chicken scratch, hopefully not as bad as mine. Then, have this whole conversation, you turn it in, somebody else turns around and types it into the computer system. Useless to me. We've fixed that. What we do now, very soon, is that information is going to be entered directly into the computer. The member can do it from the comfort of their own home, or if they don't want to do it there and they really want to come in person, maybe they don't have a computer at home, it's still going to be entered in directly in the office. We don't need to have the redundancy of extra paper or of someone entering the wrong tax withholding just because somebody made a mistake. Just looking at making the system as accurate and efficient as possible for the best customer service. Everything that we've done, implementing IRIS, carefully reviewing all of our data, it's all done to make the system accurate and efficient. So I'm very excited about this. You can go ahead, Thanasi, if you'd like before I finish my
I just want
comment.
to know, is this really helping our members? Because I think as a retired member who can't see, who has arthritic joints and is retiring, that maybe the help of a young, fresh-eyed person who can type is probably better than them having to go online and do it by themselves. And how many calls are we now going to get with, I can't get into my system, can you help me? And I think of poor Tom, who he's disabled half the time anyway. I don't even know how he's going to do that.
Thank you for these excellent questions. In preparing for this project, we looked at our membership group and we polled them and looked at what they were interested in, and they really are interested in using the online services. A very important feature of the online features, Shanasi, is you can push a little button and it'll make the type get really, really big so that anyone can see it. It's completely ADA compliant. Additionally, if someone does not want to enter the information online through their member portal, they can certainly do that in the counselor's office with the young, fresh-eyed counselor entering the information for them. But before that information is finalized, the summary is going to be shown to the member, make certain that it's exactly what they want, and they would sign it and submit it. So, important thing that I want to note is that we will continue to have personal counseling appointments. That's an important part of the process, and we're happy that we offer that. But this is part of our comprehensive approach to the retirement process. We want to front load the process so that members are educated all through their career. They're coming to seminars, they're looking on the website, they're reading the materials, and they create their own member portal account, as you all know, where they can look at their service credit and their balance and look at the options available to them. Then, when they come to be within 6 months of retirement eligibility, magically, the application feature appears on their member portal. Easy to follow instructions. They're at home where they have access to the address of their beneficiary and things that they need to fill out.
Do they get notice that it's there?
Yes, they do.
Email?
Yes, and it would be part of it is that we will be putting forward the outreach campaign for this when it is unveiled at the end of June. And members will continually be invited to come to this seminar, and then you will be instructed on that online application process in the seminar in addition to regular information coming to them.
But on that 6-month anniversary, when their member portal suddenly springs this new form out, how do they know that it's there so they go on?
Yep, multiple features to that. One is the continued outreach for members of letting them know that this feature is available. But additionally, we have regular outreach to members letting them know when they're approaching eligibility, and that will include the information that it is online. So I agree with you. We're not leaving it to them just to happen to turn on the computer that day.
It'd be really cool if at the same time that it popped online, they got an email with a link.
That'd
Yes.
be awesome.
Yes. The way the member portal works is that it is linked to the email you sign up with, which gives you notifications. So I agree with everything that you're saying, and it's been very exciting and challenging, but fun to come up with the ways that we can make it be the most efficient for members.
The other thing I thought of that you may have already dealt with, but I don't know how many times I've put data in wrong, whether it's when I re-entered my password they didn't match, or whether my credit card number was wrong, and so I get a bounce, the form never gets, it submits, the wheel turns, and it comes right back to me with some red ink that says, you made an error, and I have to go find my error. It happens all the time. Do we have any kind of feature, fail-safe feature like that so that when people put data in, it's not wrong?
Yes. So while you are filling out the application, immediately while you're on a field, if you entered, say, too many digits for a birth date, it would give you that message there immediately telling you what that issue is. So we've been working on this for a year now and have done extensive testing with folks who are not as smart and savvy as Michelle to make sure that the average person could utilize the application. So we've been continuing with our user testing to make sure that it will work for folks. And of course, we'll take feedback once we unveil the process. So we're really excited about it, particularly because of the service that it offers to members.
Do we pre-populate things that we already know, the member's birth date and those kind of things, or?
There is a set of data that does pre-populate with what is in our system, particularly the name and address and such information. So yes, and that was part of the excitement, was looking at what we can provide and then what we want to make sure that the member thinks most about. Most important thing to think about is what benefit your option you're going to pick, and that's where the big discussion will come. So really looking forward to that. And then after that is unveiled, we'll do a demonstration for you later on in the year, showing you how that's working and giving you feedback. We've already designed our metrics and our analytics to see how successful it is, and looking forward to how that works for members. So I wanted to thank Michelle Wegner for her great work on that, and our other core team member is Shawnquanna Pemberton, who is in the back. I'm going to start checking that every time. So thank you very much to them. And I can't let a moment go by without complimenting our call center staff. Oh my goodness, I love looking at those statistics. So I want to note that April and May mellows out a little calm before the big wave that comes in the June open enrollment, where I expect the calls volume to double. So it's been not horrible call, but more than 2,000 a month. And the call wait time for, I report through March on my report, but the call wait time for April was an average of 15 seconds. And it is the 11th of May today, and I don't like to get too excited about stuff. Just kidding, I do. is 11 seconds. So just so proud of the team, and Shaq just does an amazing job of motivating them and just being a great mentor, and truly everybody just wants to serve our members. It's a great bunch, so thanks to all of them.
Just because it's going so well doesn't mean we shouldn't recognize it. So
absolutely. I always toy with this. I don't want to get your hopes up too high, but I'm pretty sure they're already high where I want them, and I appreciate that, Val. So I thank you all very much for your great attention to the service that we provide to our members. I want to give a special birthday shout out to Tom, who, as an elected member, definitely gets questions all the time and is my text friend to assist the members. So if you have any questions, glad to answer them, but thank you very much for all your support.
Thank you.
Thank you. Johnny, what's the maximum gift we can all chip in to get him a birthday present without violating all the rules? 50. 50, okay, good, just checking. Per. Oh, fantastic.
All right. And then our next report is Benefits Administration, and Marcel.
So we discussed changing the order of these, and I think we're going to have to, because I just am tired of following Cynthia on these reports. I do have one thing that I want to point out I'm very excited about. If at the very, very bottom of my report, we talk about how many PSC applications are pending, and there has been one for the last 2 months. Not the same one, but we have gotten down to 1, which is incredible. That is a huge improvement from when there used to be a 6-month to 1-year wait to get your PSC processed. So they're getting processed within a month of when they come in. So very excited about that. I want to talk about 2 things that happened very recently since this report that are not in there. One is the healthcare booklet that goes out to all City of San Diego retirees and goes through what the changes are in healthcare premiums and allowances and talks about how to submit for reimbursement. So Sandra Clausen and her team did a fantastic job of updating that. They got input from retirees and from City Risk Management Department, and they were able to reduce the booklet by 20 pages this year without losing any of the content. So that was a big accomplishment there. And then I just got back from the CEM benchmarking conference in Chicago. If you remember, we had some discussion of the CEM benchmarking study at the board retreat in February. They have a conference every year for the members who participated. So 56 of the 72 systems that participated in benchmarking were there. Most of the people that I met there had the same job function as I do, so it was really good information. There were people there literally from all over the world: Canada, UK, Australia, Netherlands, Sweden, one woman from Oman, first time that she'd been to the United States. So it was a very good conference, a lot of ideas that we can talk about and a couple things that we can start using right away from that. And I'm happy to answer any questions you may have on my report.
None are in the queue. Thank you very much. The last 3 reports.
Doesn't Mark want to say something nice about her, like how important she is to the team and the few? I mean,
Apparently she's not a
You've
superstar.
shamed me into this. I had it ready to go.
Oh,
and I-
sure,
and-
yeah,
and
right,
in the
right.
interest of time, I was going to cut it short. Here's what I would like to say. Our head count at SDCERS has gone from 58 to 50 people. We're down 8 head counts, and 6 of those are in the benefits administration area, which has never run better than it's running today, despite the fact that we're taking stuff out.
Oh, finally,
So-
got rid of the dead weight people who weren't doing what they're supposed to be doing, apparently. Dragging the whole department down, I guess. All right. Just checking.
And now I actually want to pay Ted a compliment before he speaks, just in case I don't have a chance later. So on Tuesday, we presented to the City Council our fiscal 18 budget. And Ted shared some statistics about how the number of benefit tiers that we are administering has increased, how our plan membership is still going up, despite the fact that our costs have been coming down. And he said we're doing more with less. And Barbara Bree, who was the chair of the council's budget committee, closed off the presentation by saying to Ted, wow, you're doing more with less. Great job. So anyway, good presentation at City Council. Ted did a great job.
I'm going to trademark that as our motto coming up. I want to start off by saying I am really happy I get to go after Marcel, because Cynthia is a tough act to follow, and I can't be throwing
Marcel's
my...
not?
Well,
No, I think you've
Marcel
been- I
doesn't
think you've
throw
been-
papers in the air, so I'm
Marcel has
like,
been totally dissed today.
you know, no.
Don't keep digging your hole there. Just go ahead and give your presentation. Is what
Sorry,
I would do.
Marcel.
I'll tell you what.
Finance update, Ted.
Okay. First off, finance is current with financial reporting through the month of March. We're in the middle of the April close. We've done the budget versus actuals report through March, which you have before you. As Mark noted, we are now complete with the FY18 budget, which culminated in the presentation before City Council on Tuesday. Currently, we're working on the documentation project, improvements to financial reporting, which will actually come about at the July meeting. And gosh, it's here again. We're preparing for our annual audit. I feel like I've been in one long audit period. And one of the things that's not in the finance report, I've just realized that we were notified by the GFOA that we received the Achievement and Excellence in Financial Reporting for our CAFR. And then we also received the PAFR reward for a great PAFR for the FY16 year. So that marks, in my case, the 4th consecutive year that I've been a part of that. I think like 9th overall straight. Turning to the actual financial statements for the month of March. We're looking at net position of $7.3 billion in investments of the same. We had a total additions of $839 million. That's broken up into two major components. $262 million in recognized contribution income and $577 million in net investment income. That's offset by approximately $380 million in payments of administrative expenses and benefit payments, resulting in a net increase of $459 million. This is a great change in comparison to where we were this time last year. And also, we continue to increase. The last time I presented financials were for January, and we were at $354 million in net investment income. So as you compare to the $459, you see that we've been increasing over the last several months. We have total reserves of $5.8 billion. This is an increase of $74 million. And you might wonder where that net increase of $459 million is actually going to in relation to our net position. If you just examine the unrealized gain or loss and compare it to where we were last year, you can see a significant increase in our unrealized gains with our investment portfolio, and that's a credit to our investment team.
Looks like we're up about $550 million, which accounts for most of that change.
Correct. With that, I will go directly into the budgets versus actuals. Our total expenses for the 9 months ending March 31st is $34.1 million. Overall, we're under budget, and as I've explained in the previous two budget commentaries for the 3 months and 6 months, we will probably be under budget for the full fiscal year. But in breaking it down into the administrative expense component, we're at $9.7 million for the 9 months. This is 4.6% below the $10.2 million budget. IT, general ops, salaries and fringe and legal expenses were all down. In comparison to investments were at 24.3 versus a budget of 25. That's a decrease of 2.7%. And once again, this deals with the fact that we started the year with a lower portfolio value. Previously, both for
Looks like it's mostly equity and fixed income management fees.
Correct. So when we did this in January, where I presented the December numbers, I noted that both private markets and public markets were lower from a investment management fee perspective. And if you looked at the financials, you can see that actually equity and fixed income amounts are actually higher now, and that reflects the fact of the growth in public markets. Our CapEx budget, as Dave Bond remarked, he gave a not-to-exceed price of $135,000. As he pointed out, and probably should be highlighted, this was a very, very late issue that arose at the end of April. At that time, I had a figure of approximately $125,000 and found out that they'll also have to include tax in that, which is why Dave came up with that not-to-exceed price of $135, yet my report says $125. So I estimate it to be at that $135 level, as David pointed out. And with that, I will open the floor to any questions you may have.
No questions.
Oh, come on.
Nice report. Good report.
Thank you.
All right.
All right, fine, it was a good report.
It was not as good as Marcel's, but it was good. All right.
Thank you.
So that leads us to questions and comments from the chair, trustees, and staff. My only comment is I do want Tanasi to know that the B&G committee really appreciates him being here, and we meet on Mondays at 9 a.m. All right. Anything from Mark? All right. Happy birthday to Tom. A great trustee. And that brings us to non-docket items, of which I believe there are none. And so we are adjourned.